Subparagraph 8.3 of resolution dated 22/8/2023, to the extent it contemplates preparation of district-wise draft merit list and further stipulates that the district preference will be preferred over merit, is ultra vires Article 14 and 16 of the Constitution of India. The said prescriptions do not have any legal justification. Rather, it defeats the basic object to attract the best talent from amongst the successful candidates. Such provision results in discrimination without any nexus between the requirement of preparation of district-wise merit list on the basis of first preference and the object to be achieved, that is, selection of meritorious candidates for the post of teachers, which is one of the avowed objects of Section 8G of the RTE Act to ensure good quality of elementary education, conforming to the standards and norms. The importance of good quality elementary education has been noted in case of Devesh Sharma. Paragraph 8 of the resolution dated 22/8/2023, to the extent it provides for giving preference to the candidates district-wise over merit, cannot be saved by applying the rule of purposive construction, the language used therein being unambiguous. This court cannot permit clause 8.3 of the resolution dated 22/8/2023 and other follow-up provisions under the resolution to operate, which is patently discriminatory and violative of Articles 14 and 16 of the Constitution of India. Though the said provisions have not been challenged by the parties, it will otherwise amount to requiring the appellant state of Odisha to follow a procedure in the matter of public employment, despite the said procedure having been found to be unconstitutional in the light of a constitution bench decision of this court in case of P. Rajendran. After having concluded as above, we are of the considered opinion that the entire selection process undertaken by the appellants for recruitment to the post of junior teacher schematic should not be declared illegal, as that will hinder the completion of process of selection and seriously affect the teaching/education at the school level because of dearth of teachers. We deem it expedient in the interest of justice in the given facts and circumstances of the case to resolve the absurd situation arising out of the stipulation in paragraph 8.3 of the resolution dated 22/8/2023 in a manner that is just, equitable, fulfills the mandate of Articles 14 and 16 of the Constitution of India, and at the same time furthers the objective of Article 21A of the Constitution, read with the provisions of the RTE Act. For the said purpose, we consider it just and proper to issue following directions for the selection process in question. No illegality has been noticed in the conduct of the CBT. Therefore, the marks scored by the aspirants in CBT shall be the basis for determination of the merit of the aspirants. Second, based on the CBT held by OSEPA, the state appellant shall fix first set of minimum cutoff marks, category-wise, subject-wise, taking into account total number of posts advertised, considering the marks secured by respective candidates in the said test. Select lists shall be prepared of such candidates having secured the cutoff marks or above. The preference given by the candidates at the time of application shall be considered for allocation of districts based on merit cum preference. The minimum marks scored by candidates declared successful by OSEPA, subject-wise, category-wise, may be fixed as the first set of minimum cutoff marks. It will be open for the state appellants to refix the set of cutoff marks later from time to time in the event the posts remain unfilled because of non-joining of candidates or other similar reasons, which shall be confined to the number of posts advertised. In view of the admitted fact that score of writ petitioners in the online CBT is less than the minimum marks scored by candidates declared successful by OSCPA, subject-wise, category-wise, we allow the state appellants to appoint such candidates, taking into account their merit based on score in the CBT and direct preference and district preference for the purpose of allocation of a district. It goes without saying that cases of the writ petitioners shall be considered against leftover vacancies in terms of the direction as above. The directions issued by the learned single judge stands modified accordingly. The writ appeals stand disposed of.